name is Heather Cantino. I live in Athens, and I've been working on fracking in relation to the Wayne and injection wells since 2011. My topic is federal fracking of forests, a human rights issue. Among human rights set forth by the Global Network for the Study of Human Rights and the Environment's Declaration on Human Rights and Climate Change is that, quote, all human beings, animals, and living systems have the right to a secure, healthy, and ecologically sound Earth system. Furthermore, the Declaration states all human beings, animals, and living systems have the right to the highest attainable standard of health, free from environmental pollution, degradation, and harmful emissions, and to be free from dangerous anthropogenic interference with the climate system. This climate stability depends on, among other things, 1, the protection of intact, mature forests whose trees, soils, and water provide massive carbon sequestration and climate stabilization, and 2, keeping public fossil fuels in the ground. The vast holdings of public lands and implications of opening more of them to extraction make federal lands and their forests critical to this central human rights issue. These are the only forests that the public can theoretically protect, since they belong to the public and can be subject, more than private forests, to governmental protections. Yet mature and old-growth forests are increasingly rare and threatened by government mismanagement and commercial exploitation. This is especially true in Ohio, where public lands are in the bottom 6% of states per capita, where state-owned forests can be clear-cut at the will of the chief of the Division of Forestry, and where even state parks have been open to fracking, as Rick mentioned in House Bill 133 in 2011. The most recent Intergovernmental Panel on Climate Change reports endorse a global carbon budget in which 67% of the world's remaining fossil fuels must stay in the ground. Other scientists say closer to 80% must not be extracted to avoid catastrophic climate change. Yet 23% of total U.S. climate emissions are the result of burning fossil fuels from public lands and waters. Oil and gas leases generally run 10 years and generally renew automatically, which means that corporate contracts, rather than science, govern U.S. policy at a time of this rapidly closing window in which we can reverse climate devastation. This is a far cry from the role that corporations were allowed to play under early American law, when they could be abolished if they did not serve the public good. The National Environmental Policy Act, NEPA, quote, our basic national charter for protection of the environment, unquote, requires agencies to undertake thorough, site-specific environmental analysis using up-to-date science prior to any retrievable commitment of resources. The primary tool, as Roxanne Groff mentioned, is the environmental impact statement, which must be prepared when impacts may be significant, and especially if effects are likely to be highly controversial, highly uncertain, involve unique or unknown risks, or may significantly impact health or safety, or may impact endangered or threatened species habitat. Courts have ruled that federal agencies must assess climate costs and benefits, including effects on the economy, environment, and public health. In spite of federal commitments to curb emissions and to consider climate impacts, the U.S. government continues to behave as if no fossil fuels are off limits. Specifically, Ohio's only national forest, the Wayne, has conducted no NEPA-based evaluation of fracking impacts on climate or on anything else. Its most recent plan, which dates from 2006, did not even consider fracking. The Bureau of Land Management, BLM, which, given U.S. Forest Service consent, manages the leasing of federal minerals under the National Forest, has never done a site-specific EIS or ever considered climate impacts of fracking the Wayne with up-to-date science as required by NEPA. Nevertheless, the Wayne gave consent to the BLM to lease last year, well, we're not sure exactly when, And in spite of dozens of substantive formal comments by citizens and legal teams protesting its shoddy and illegal process, the BLM conducted 2 online fracking auctions of Wayne land this past December and March. All 40,000 acres of federal minerals in the Marietta unit of the Wayne are expected to be auctioned off in the coming year or 2. U.S. Forest Service consent that enabled these sales took place in spite of 5 years of widespread opposition and extensive formal appeals based on legal, scientific, and economic arguments by local citizens, government officials, academics, business owners, tourism representatives, a university president, mayors, a city council and county commission, and legal teams representing grassroots, regional, and national environmental organizations. Thousands of petition signatures, hundreds of letters, and dozens of meetings with officials called for an EIS or an outright ban on fracking. Citizens also provided dozens of studies and more citations from the now substantial scientific literature on fracking impacts on air, water, soil, wildlife, ecosystems, public health, greenhouse emissions, and local economies. And so U.S. officials' refusal to authorize a new forest plan or a supplemental EIS make the federal government's consent to lease both illegal and a clear abuse of human rights. Like the Forest Service, the BLM refused to prepare an EIS, nor did it conduct even the less rigorous site-specific environmental assessment that's required before leasing. The broad programmatic EA, environmental assessment, that the BLM did do was so shoddy and lacking in any rigorous science that its finding of no significant impact, or FONSI, is also a travesty of justice. The BLM, EA, and its FONSI violate NEPA for the following reasons, among many. First, climate impacts. The EA assumed that methane is only 25 times as potent a greenhouse gas as carbon dioxide, contrary to the IPCC's recent updates of methane's 100-year global warming potential to 36, and more significantly, of its 20-year global warming potential to 84. The BLM also did no analysis of social costs of carbon, therefore effectively assuming a price of carbon of $0. This is in contrast to the EA's quantifying the supposed economic benefits of extraction without consideration of public costs. Thus, our government is misleading the public on the costs of oil and gas production at a time when such deception is extremely dangerous. BLM also failed to take a hard look at impacts of opening private minerals. By opening federal minerals to drilling, adjacent private minerals will be of significantly more interest to fracking companies, especially given the patchwork of federal and private ownership in and around the Wayne, since companies will consider it cost-effective to invest in the larger projects, and in some cases where that's the only way they can legally have a project if they have enough acreage. If the Wayne did not lease, fracking would be much less likely to occur on the adjacent private land as well. BLM did not assess this situation and its clearly significant impacts, including total land degradation, water and air pollution, climate implications, habitat loss, and disturbance to wildlife on both Wayne and adjacent land. BLM also did not do a the NEPA mandated assessments of cumulative and indirect impacts of leasing. Extensive life cycle methane leakage, as well as carbon dioxide emissions from oil and gas operations, effectively make these fuels worse for the climate than coal is, in part due to fuel switching caused by investments, subsidizations, and incentives that distort actual real costs, and industry-fueled misinformation about comparative emissions of coal versus gas, which have led people to say that gas is clean. Emissions during extraction, during transportation, including compressor station processes, and during use and waste disposal have been widely underrepresented and underestimated and underreported. Pipeline build-out and its destructive impacts, as well as the permitting of liquefied natural gas facilities that our last speaker mentioned, which promote the increasing commitment of gas for export, all mean that fracking here disincentivizes clean energy and conservation worldwide. Given the vast supplies of oil and gas controlled by the federal government and its power over infrastructure permitting, our government's abuse of the law and its denial of science and public welfare are resulting in human rights abuses of global proportions. I don't have time to talk about the impact on species, but if you read it, I go into impacts on bats, which are totally unrepresented in the EA and are extremely critical, and also of water withdrawals and all the other problems associated with gas operations that you've heard from previous speakers. And they also, I think, important to look at is the importance of Ohio's lax regulations and how they fit into the picture, because Ohio is in charge of the permitting, and therefore all you've heard today about Ohio and its regulations is relevant in terms of Wayne leasing as well. Thank you.
So is it correct that there are some organizations that have filed a lawsuit against this? Is it the case that there are some organizations in Ohio that have filed a lawsuit protesting this finding of no significant impact that
Right.
Fonzie?
Yeah, and actually I used that, or some of the preliminary documents. The Center for Biological Diversity has filed a lawsuit, and Sierra Club and OEC have signed on. There were also formal complaints to the BLM on their leasing prior to the leasing that Athens County Fracking Action Network and Buckeye Environmental Network, of which I'm a part, we're also party. We're not on the current lawsuits, but yeah, there's a suit has been filed against the December lease sale. I'm not sure if it's been filed yet against the March one.
So what's the feeling about the possibility of success?
Well, I guess it depends on who's left on the courts when it gets around to being heard. And, I can't say.
Is there a record of success or failure of this kind of suit that you are aware
I
of?
think some lease sales have been overturned in the courts, even following the lease sales, but I'm not the best person to ask that.
So I have a question. You said the BLM did not do a NEPA mandated assessment. So if the mandated assessment, how could they not do that? I mean, is it a legal mandate that they do that, or?
Well, that's the whole thing about this, that they're not following legal mandates, and that they, instead of doing a site-specific EIS, which is required under NEPA, they did a programmatic EA, so it's this broad, extremely shoddy document. In fact, one of my comments on the draft version of it was, well, you cite Bamberger and Oswald, which is a really important study on the impacts of fracking on animal health, and how can you cite this and then come out with a FONSI? And so their response in their final EA was, oh, we took that out, because they weren't actually citing it for its conclusions. They were citing it for something totally irrelevant, like how much water was withdrawn. So their answer, their science is to get rid of the science when it doesn't fit with what they want to be producing. I've also said that document was not even worthy of a high school report. It's so illogical, so poorly done. So NEPA, if we had responsible people interpreting it, who are not being bought off or pressured from above by people who are being bought off, it has been a valuable tool, but not the way, and it's not just the current administration, but the previous administration allowed their administrators to interpret NEPA and skirt it. So the BLM kept referring to the supplemental information report, which was done in 2012, based on our opposition to leasing at that point in 2011. And instead of doing an EIS, they just did a SEER report and keep citing it, but that's not a NEPA-based document. So they're just trying to get away with what they can.
And what's a SEER report, just for the record?
That's the supplemental information report, which again, just took the 2006 numbers and said, oh, fracking's not really very different from conventional oil and gas drilling, so there's really not a problem here.
So it's up to the administrator of the BLM to decide whether or not an EIS is required?
Well, the U.S.
Is that how it works?
Well, I don't know at the BLM level. In the U.S. Forest Service, it can either be the forest supervisor or the regional forester who is in charge of deciding. But it's based, their criteria. NEPA's a vast law that has, very clear criteria about when it's like those things I read about. If something's controversial and if it may be a significant impact, an EIS is required.
But
So,
it's also discretionary.
Well-
They're the ones to make the decision, and that's.
I don't know. I don't know what a court of law would decide about that.
Thank you, Heather.